Oh, yeah. Hello, everyone.
Hello, this is Jade.
Hey Jane, it's Karen.
Hi, Karen.
How are you?
Good. How are you?
Good. Your picture's not on, but we'll be okay.
Hello, everyone. Can everyone at home hear me?
Yes.
Yes.
Am I on mute?
You must be. No,
We can hear you. I'm going to mute me so you don't have any other.
Hello?
Hi,
Can people at
Professor.
home hear me?
Yes.
Only can hear you if I'm off.
Yes.
I knew what was
Yes.
going on here.
Can only respond if we're unmuted. I mean, mute. Yeah, I'm mute. I'm muting myself now.
But when I mute myself, Professor, I can't hear you.
Hi, Adam.
Hi, Karen.
Hi, everybody. It's nice to see everybody. It's just different being home and everything. All right, I'm muting.
For some reason, everything is turned down. Can you folks hear me at home?
Yes, I can.
Yes.
Yes.
Gotcha. Thank you. Is my PowerPoint slide up at home? You all have that?
Yes. Yeah.
Yes.
Okay, let's start up. Couple of things to remind everyone of. Teddy, could you turn yours down a little bit, please? Thank you. No, not a problem. When you're speaking, please, lean into the speaker so that everyone in the class lean into the speaker so that everyone at home can hear you. Probably a good idea for folks at home to turn off mute or turn on mute, except when they're speaking. Of course, if you hit the space bar on your computer, at least on a PC, that will instantly turn off mute if you want to speak quickly without searching for the mute button in order to speak. And obviously, speak up whenever you want, whether you're at home or in the class. We'll try to keep this as interactive as possible. We had started the justiciability doctrines. Oh, by the way, I will later on today, I will post the answers to the quiz that you all took over the weekend, okay? I like to get your feedback as soon as possible. And everyone, has taken it, who's going to take it. So I will get those answers out for you. And perhaps on Thursday, we'll even discuss them a little bit if anyone has questions on them and the like, okay? All right, so we're going to continue with the justiciability doctrines. If you remember, advisory opinions, standing, ripeness, mootness, the political question doctrine, and then finally one that's not in your book, but is important, is the adequate and adequate state grounds abstention doctrine. We'll get into that one last and spend a little bit of time on that. That is tested on the bar exam. We didn't quite finish up advisory opinions. The main case that we looked at was opinion of the justices. Obviously, a very old case during the first term of George Washington. Secretary of State who was Thomas Jefferson, sent a letter to the Supreme Court asking it to answer a series of questions regarding particular actions that might be taken by the government and by merchants and contractors, in what effect it would have on the neutrality position that the United States had taken. The Supreme Court politely and firmly declined to do this. It said to do so would be a advisory opinion, and it would be asking the court to render a decision on a hypothetical dispute that may not ever arise at any point. And you know, really, it was for the courts to resolve actual disputes between real parties, right? Not projected disputes or not speculative disputes, but actual disputes. I think we ended there and did not get a chance to look at the Plout versus Spendthrift Farms case, 1995 case. Decision written by Justice Scalia. So we have this securities law and Rule 10b in Rule 10b-5. And shortly before, a few years before this case was heard by the Supreme Court, in another case, the Supreme Court ruled that actions under these statutes, civil actions, have a short statute of limitations. They're required to be brought within 1 year of discovering facts that give rise to the violation. And within 3 years of the violation, even if the facts weren't discovered, the 3-year statute of, these are called statutes of repose, would run out. Congress then apparently in response to the Supreme Court's decision goes, and this is not unusual for Congress to do this, and does Congress have the right to do this, right? Remember, under separation of powers, what is Congress's role? The right to make law, right? Congress makes the law, the president enforces the law, the courts interpret the law. So if Congress makes law and the courts interpret it, and Congress doesn't like the interpretation that is given, this is why we edit our documents, right? We do it constantly. You know, on the first read, you see, geez, that's not really coming across the way that I wanted it to, so let's go back and edit it, amend it. So Congress certainly has the right to go back and change its laws. But in doing so, what it did is it changed the law and allowed longer statute of limitations. And it said, and this is the troubling part, it said it applied to cases that the federal courts had already decided under the law. And so the effect of the statute was to reopen actions that had already gone to judgment, that had been dismissed under the court and become final under the court's prior ruling. And the Supreme Court sees this as a bridge too far. It has usurped the power of the court, the power assigned to the judiciary under Article 3, in violation of separation of powers. And what Scalia writes about is essentially describing what courts do. Courts hear disputes. Think about the rules of civil procedure, right? If you think about the rules of civil procedure, they're actually set forth in a very logical fashion. They essentially track the chronology of a civil case from the very beginning when personal jurisdiction attaches all the way through judgment, final judgment, and then appeal, right? And you can't appeal before the final judgment, right? So there has to be a final judgment, and then there's an appeal period. In most civil cases, the appeal period is something like 30 days. Sometimes it's longer if a government is a party, 60 days, for example, if the government is a party. But there are, appellate periods that are prescribed by the law. And if the person does not appeal, at that point, there's nothing you can do with the judgment. It's final, it will stand forever, okay? So here, you've got final judgments. The appeal, they either were not appealed, or the appeal period has run without an, the appeal period has run without an appeal, or they were appealed and the appeal was decided. And so everything is absolutely final. What is Congress telling the federal courts they have to do? Reopen the cases that had been finally decided under the old law. And as I say, Scalia says this is a bridge too far. Courts render final judgments. If you take away the ability of a court to render a final judgment, you are taking away the judicial power from the court. You're essentially saying that every single case decided is an advisory opinion, because Congress can come back and change the result almost case by case if it wants to, okay? And that is essentially nullifying the judiciary altogether, usurping power. Now the court is acting as, now the legislature is acting as the judiciary as well as the legislature, and that's a violation of separation of powers. So this last slide I have on the case says, legislation like this that can reopen cases. Scalia pointed to the previous decisions, and he said, look, if the court had come in while the case was ongoing and directed a result, that would be fine. I'm sorry, if the legislature came in and amended the law while the case was ongoing and made the law retroactive, it had the right to do that. But once a final decision is made, it has to be a final decision, or else there is no judiciary, essentially, okay? So what happened here was constitutionally unacceptable. All right. Now, to quote Professor Rodriguez, what am I going to say?
This is important.
Thank you. This is important. I mentioned this in the last class. Of the justicialbility doctrines, standing is the granddaddy or grandmummy of them all, okay? It is going to be on the bar exam. I can promise you. And I told you 2 ways it's going to be there. It's going to be on the multiple choice questions, and you're almost certainly going to get a con law essay question on the other day of the bar exam. Bar exam's 2 days. Second day for you folks is the 200 multiple choice questions. That's why we're doing multiple choice questions. By the way, quick aside. How do you guys like multiple choice questions? Did you find some of those hard? They are very hard. They are very, very hard.
They're hard, but I'd rather have them than essays.
Well, I would always rather have essays. I was always a pretty good writer, and I could always get my way through essays. All I had to do was be prepared, and I do fine in essays. And somehow I made it through the multiple choice section of the bar exam as well, because I got that envelope saying I passed. So whippy. I wouldn't be here if that didn't happen, I guess. This is a work in progress, guys, okay? Don't get discouraged. I understand it's frustrating. It's a work in progress, but keep thinking as you're getting your answers back and you're analyzing the questions. Here's a really good practice. when you get your answers back, go back and look at the questions asked and look at every single answer for that question, A, B, C, or D, and figure out to a certainty why each one was right and why each one was wrong. And that will start to train you how to think about these questions. And you guys know that the sports analogy is muscle memory, right? Do you think that all of a sudden Marcus Smart is a great three-point shooter? Do you think that as Marcus Smart is taking his three-point shots, he didn't used to be, by the way, a good time for him to blossom. Do you think as he's taking his three-point shots, he's thinking about how he's going to hold up the ball and how he's going to snap his wrist just as the ball is released and what kind of rotation he's going to put on the ball? Well, he did when he was a young player learning how to play the game. His coaches broke it down step by step for him to do that. Then after a while, it becomes pure muscle memory, and your brain is thinking, but you just aren't quite realizing that your brain is thinking you through it. And the same thing happens here, is that the more you think about these and break down step by step at the beginning, learn how to do multiple choice questions, then later on, when you get to the bar exam, I hope it's going to be muscle memory. You'll have figured out what you're good at, what you're not good at, what your particular learning style suggests that you do in order to approach these questions, and it will become easy. They're never going to be easy, I can guarantee you that. The bar exam sucks in every way possible. And testing lawyers on multiple choice questions is a totally invalid way of testing lawyers. I've been a lawyer for 39 years and I have never practiced a single day of multiple choice law. I've never had a client come in and tell me a story and then give me 4 choices of the right answer. It's sitting there, okay? But you got to dance with the devil, don't you, in order to become a lawyer. And unfortunately, that's what the bar exam is. The bar exam requires multiple choice questions. So I'm a believer in starting you out early with those. Those of you who have already had me for real property have already been through a bunch of multiple choice questions as we've gone through the course. So you're going to get at least a couple, out of the 27, you're going to get at least a couple of multiple choice questions on standing. On your con law essay, almost always, not always, but almost always, the first issue you address is whether the plaintiff has standing. Okay. It is a jurisdictional question. It's a procedural question that has to be dealt with prior to getting into the substance. Now, on an essay, you guys understand that even if you decide that there is no standing, that doesn't mean you get to say, hey, there's no standing, I don't have to discuss the substance, right? What do lawyers do in briefs? So if there's a motion to dismiss brought, and the primary ground of that motion to dismiss, that 12B6, is a lack of standing, do you address the substantive issues in that brief as well as backup issues? You're damn right you do. You say, even if there is standing, the plaintiff has not stated a cause of action, a claim upon which relief can be based. So the court should still dismiss. And that's what you do in your essay answers as well, okay? What's that, Teddy? Well, arguendo is, yeah, assuming we disagree, but even if it were the case, we would argue this, okay? All right. Article 3, Section 2, Clause 1. Oops, I forgot to close in the parenthetical. This is the case or controversy clause. You don't see the word case or controversy strung together. They're used throughout this. We've looked at this before when we talked about the original authority of the Supreme Court, okay? And when we talked about the appellate authority of the Supreme Court as well. So the judicial power shall extend to all cases, and goes on to say what they are, and then to other sets of cases, all cases affecting ambassadors, etc. And then to controversies, in which the United States is a party, and then controversies between two states. Hence, case or controversy. There has to be a case or a controversy for a court to exercise judicial power. And again, the reasoning for this is, if not, then the court will be acting more as a legislature than as the judiciary. They will be trying to read the tea leaves, trying to project about what the law would be if these facts occurred, right? And that would be speculation. And we've already described the legislative process. They investigate, they try to cure the evil, and then they create laws to deal with curing that evil, okay? So this is from where standing emanates. There are two types of standing. And standing, as I've suggested here, requires skin in the game or a dog in the fight. However you want to, whatever colloquialism you want to use to describe it. You know, if I'm a friend with someone who was involved in an automobile accident and has suffered an injury, have I been injured as a result of that automobile accident? No. So therefore, can I bring that claim myself? And the answer is no. In a very broad, rough way, I'm giving you just a really rough, you know, overstated analogy. I wouldn't have standing to bring such a case. I wouldn't have skin in the game. I've suffered no injury, and I wouldn't be able to bring that case, okay? So that's what we're really getting into here. Does the plaintiff have a significant enough stake in the lawsuit that he or she is bringing to sustain the case or controversy requirement? There are two types of standing. There's constitutional standing, there is prudential standing. Learn those phrases. You are going to be tested on them. You're going to need to know the difference between constitutional standing and prudential standing. Just like original jurisdiction of the courts, constitutional standing is prescribed by the Constitution. It is right there in Article 3. Just like original jurisdiction, Congress cannot waive or expand constitutional standing, okay? And you will see Congress try to do that. Congress will often write statutes, write laws, and say that certain people are deemed to have a right to bring this type of lawsuit. Translation, certain people have standing to bring this type of lawsuit. Not if it violates constitutional standing. Utterly, entirely unwaivable, okay? Now, prudential jurisdiction, standing, prudential standing says that in some cases, it is not wise, it is not prudent for the courts to entertain such types of cases. And so it's, I say here, it's another layer of insulation. Even when Article 3 does not compel the courts to decline jurisdiction, sometimes prudential jurisdiction will be used to do so. This one Congress can tinker with. Congress can say there is prudential standing in this case. You still have to satisfy constitutional standing, but you can say there is prudential standing. One of the biggest things we're going to see, we're going to look at the areas of prudential standing. One of the ones that's the most common is a so-called generalized grievance, sometimes called taxpayer standing. Your standing as a taxpayer alone does not give you the right to sue the government. That is a matter of prudential standing, okay? You have to show discrete, particularized harm to you to have constitutional standing. Even if you do, the court may well say, but because this is generalized standing, you know, we're not going to hear this case. So today we're going to deal with constitutional standing. Hopefully we'll finish it. I got a lot of slides to go through, and a lot of cases. Hey, one more comment about the cases. If you notice, the way that this author handles cases is he tends to give you a big case, and then there are notes following the case with a number of smaller cases that come in those notes, right? Read the notes, read the cases. I'm going to do a lot of them, most of them in class. And I told you the reason on the first day of this semester. The reason is those fact patterns are going to appear on the bar exam, whether they're in the notes or whether it's one of the primary cases. Those fact patterns are what the questions on the bar exam will be based off when you take the bar exam. So I stress once again, the cases in this course are very, very important, okay? All right, let's get into constitutional standing. The first thing you're going to have to do is memorize the 3 elements of constitutional standing. And here they are: injury in fact, causation, and redressability. First, the plaintiff must show injury in fact. Must show that he or she has suffered or is clearly about to suffer actual imminent injury. And we'll talk about this. You'll see the cases will require particularized injury, not injury that tends to be shared with all American taxpayers, not injury that tends to be shared with all people in the world, okay? It's got to be particular injury, and it's got to be imminent. Imminent means immediately. Pet peeve, don't say eminent. Eminent and imminent are not the same thing, okay? It is imminent, which means it's going to happen pretty soon. Second is causation. Learn these words. The injury must be fairly traceable to the defendant's conduct. This is not as strict as the 2 types of causation you learned in torts. Direct causation, approximate causation, remember that? Right? Remember the what was the big case for proximate causation in torts?
Is it the house with the fire, the wind?
No, it was
I think it was the
Close
railroad.
The railroad,
railroad,
close
wasn't it?
graph.
Was the
Oh.
railroad,
No.
the one
One
at
at
the
a time.
railroad station?
The
Yeah.
railroad station
Yes.
case.
Yes.
What was the name of
Graph,
that
I
case?
think it was.
Paul's
Graph?
Paul's graph
Graph?
case.
Fallsgraph case,
Aye.
right? The chain reaction in the railroad station case. What was it, a scale that originally got tipped, and then it started a chain reaction that eventually caused an injury. We're not requiring anything as precise as that. That's why we say that it is fairly traceable to the defendant's conduct, okay? And we'll get, we'll talk about this a little bit more as we get through the causation cases. Usually, most cases are decided on the injury in fact issue. All 3 of these have to be present. If you know, it's not like that old song, 2 out of 3 ain't bad. You've got to have all 3 in order to have standing, okay? So causation, the injury must be fairly traceable to the defendant's conduct. Third, the plaintiff must show redressability. That's just a fancy word for saying, if the court decides in your favor, you don't have to show that the court is going to decide in your favor at this stage, but if the court finds in your favor, then that will abate the injury or at least provide some compensation or some remedy for the injury that you have suffered, okay? If a court is incapable of giving you relief from the injury that you have suffered, then there's no standing. There's no constitutional standing, okay? You're in the wrong place. You know, you should be seeking a remedy perhaps through the legislature under those circumstances. Because again, what is it the courts do? Courts resolve disputes.
Can I ask
And,
you a question? No?
Go ahead, Karen.
When you're talking about all this, are you also talking about equitable remedy or just, you know,
We're talking about both legal and equitable, and we'll have a case shortly directly on point
okay,
where I'll make that distinction clear to you guys.
thank you.
Understanding that there are different types of remedies. You'll see that sometimes there is standing for monetary damages, but no standing for an injunction, for example. So there's a legal remedy, but not necessarily an equitable remedy. And I'll point that out when we get to the case, okay? So the court has to be able to redress the harm or the injury that has occurred. That is our final requirement. Okay, so all together, are we ready? Let's do this together. What are the three elements of constitutional standing? Injury in fact,
Causation,
causation,
redressability.
and then you're going to have to be able to give explanations of what each one is. But though that's you know the sort of buzz phrases that you're going to have to remember. Let's get into some cases. Our first case is the case of Allen v. Wright. 1984 case. Parents probably, I'm going to date myself here. Most of you are probably a little too young to remember the whole busing era in the 1970s, late 1960s and 1970s, where public schools in cities and urban areas were ordered to desegregate their schools. And so, for example, busing was a huge problem in Boston. It caused an awful lot of civil strife for a number of years in Boston. If you think about the neighborhoods in Boston, this is changing today quite a bit. If you think about the various neighborhoods in Boston, some immediately you would recognize as being white neighborhoods, and some you would immediately recognize as being black neighborhoods. Obviously, since the 70s, they've become more diverse as other ethnicities have moved in as well. But you would have, say, for example, children going to school in Charlestown would be going to all white schools because it was a almost entirely white part of the city. And students, children who went to public schools in Roxbury would be going to almost all black schools because at that time, less so than today, but at that time, it was almost exclusively a black section of the city. This caused something called white flight. Has anyone heard the term white flight before? Both the whites and African Americans were against busing when it was occurring for one simple reason. The parents of the children were parents, and they didn't want their children being bused across to the other side of the city on these long bus drives early in the morning that would, extend the days. They wanted them relatively close to home, and they wanted them to be safe and not amongst strangers, so to speak. The people who had the economic ability to be able to move out of the city would often do so and move largely to the North Shore, the immediate North Shore of Boston, and the South Shore of Boston. And of course, people, the socioeconomics were such that this was largely white folks who had the financial ability to move. And those who didn't have the financial ability to move still had the ability to put their kids in private school. And so segregation was pretty much maintained through white flight and putting your kid into private schools. In some parts of the country, the private schools were themselves displayed racial animus. You know, so some of the, for example, some of the southern white Baptist schools, for example, would not allow black students to apply and the like. So that's sort of the backstory here for these types of cases. Busing unfortunately failed. We'll talk about that later on when we get to equal protection. It failed largely because the Supreme Court ruled that the white suburbs were not required to participate in desegregation because there was no history of the white suburbs discriminating against African Americans. You know why there was no history of the white suburbs discriminating against African Americans? Because there were no African Americans living in the white suburbs. So you know that was essentially the death knell for the attempts to desegregate the school systems. Here, parents of black public school children brought a class action, a nationwide class action, trying to get the Internal Revenue Service to enforce its own IRS rules and to enact IRS rules that were a bit stronger. And the IRS has rules and regulations that continue to exist to this day, saying that if you want tax exempt status, there are certain things you cannot do. We'll see later on, for example, is you cannot engage in political activity. We don't want to subsidize, the federal government does not want to subsidize political activity, regardless of which side, you know, of the politics is being subsidized. And the other thing that the federal government decided it didn't want to do was to subsidize racism. And so, in order to get tax exempt status, you could not be a racially discriminatory organization. And this lawsuit alleged that racially discriminatory organizations were being allowed to continue to get tax exemptions and not have to pay income taxes, despite the fact that they were racially discriminatory and seemed to be taking no steps to change that. So they say here the harm is that the IRS has directly interfered with the ability of their children to receive an education in desegregated public schools. The court threw the case out. It said that there was lack of standing. And the bottom line of why the court said that there was lack of standing is it said, you have no injury. You have no injury because none of you in this group, in this plaintiff group, have shown that you've tried to apply to a single one of these allegedly discriminatory schools and been denied entrance on the basis of your race. So while there may be general racism that's ongoing, you haven't been able to show that you have been harmed by the racism of particular educational institutions and the like. Now, an argument can be made for injury, and I think we've just, sort of discussed it, is that, if there are people who are, white folks who are moving their kids out of the inner city to avoid desegregation, and they're largely being doing it because of racial bias, if that in fact is the case, then we're being left with schools that are just as segregated as before because of the white flight. And so the kids who remain are still being harmed. But do you see that in the court's court's eyes, that is more of an attenuated argument. It is not really a direct argument. You know, the easy case, the direct argument is, I applied to this school, I had great grades, I had great test scores, but I didn't get in because I was African American. That's pretty overt, direct discrimination. And the court seems to be looking for that type of discrimination, at least in this case. All right? So no injury in this case. What could the plaintiffs have done to create standing to go after the schools that discriminate on the basis of race? Teddy? Have persons of color apply to predominantly white schools, white private schools, and have them be rejected, essentially. This happens. So many important cases are setup jobs. Essentially, a lot of the discrimination cases are setup jobs. Someone who is willing to, get arrested or willing to be the victim of discrimination in order to bring the case will put himself or herself into a situation knowingly that is going to lead to a lawsuit with that person's name on it. There are private interest groups on all sides of the political spectrum that are looking for these types of cases to advance their cause, okay? So people do this type of thing all the time. They take positions. I'll give you a couple of examples. We're going to talk about Griswold versus Connecticut, which is the case that said that married couples are entitled to use contraception. The state of Connecticut, which back then was predominantly a Roman Catholic state, outlawed abortion outlawed not just abortion, but contraception as well, purchasing contraception. Just as Massachusetts did at one time. So it was largely a black market thing when people purchase contraception. The doctor at the heart of the case literally tried to get arrested for prescribing contraception to some of his patients. And the first time he tried, his case was dismissed because it lacked ripeness. We'll talk about that later on, Poe versus Ullman. We'll talk about that on Thursday. He eventually did get arrested. They said in Poe versus Ullman, essentially, no one gets arrested for that anymore. You've got nothing, you've got no claim. You haven't established enough. He eventually does get arrested. It leads to one of the most famous cases in constitutional law, Griswold versus Connecticut, the case that established the right of privacy in the case. All the way in the back, first name, and speak right into that. I don't know if you have a laptop. No, go ahead. Okay. So Samora doesn't have a laptop. Samora took note of the dissent, which I don't have a slide on. And what the dissent here said is, you are creating a standard of standing. That's a mouthful. A standard of standing that is much too demanding on the plaintiffs. There hasn't been any discovery in the case. It's early in the case, and the plaintiffs may well be able to show the type of And I think some more, I think we talked about this, the type of injury that they have suffered, even though they haven't applied to the individual schools that allegedly discriminate, and still get their exemption, their tax exemption. You know, which is the effect of everyone leaving the public schools and going to the private schools, some of which are discriminatory, is devastating the public schools. And again, the majority, and you're going to see this throughout, and what you're going to see, and I'm not stating this as a political statement, I'm stating this as an observation, justices who tend to be conservative, and I'm using quotes for conservative because we've already talked about the difference between political conservatism and judicial conservatism. There's overlap between them, but it's not always very fine. Judges who tend to be conservative want more out of a plaintiff in regard to standing. And judges who tend to be more liberal or judicially active tend to take the position, you're demanding far too much at this stage in the litigation. Let them go forward. You know, and if they can't prove their case later on as we get through discovery, then we'll do the standing situation. Okay?
Professor, this is Jade.
Hi, Jade.
Hi. The folks at home really can't hear people talking. The class.
Yeah, Jade. That's why I repeated the question.
What was the question?
The question was what I said was that the dissent in the case said that the majority is demanding too stringent a standard of standing.
Okay.
That's the discussion that we just had.
Okay.
So when someone doesn't have a laptop, there's not a way that any of you at home are going to be able to hear that person. So that's why when I see someone doesn't have, that's why I asked, do you have a laptop?
Oh, okay.
That's why I repeated the comment that was made, which was a very observant comment, by the way.
Do you expect us to read the dissents?
Yes, absolutely.
Okay.
Absolutely. Sometimes the dissent's not here, but sometimes the dissent becomes majority. Look, these cases are often close calls. You know, when you get an essay question, you're often going to be able to argue either side of the case, and the dissents help you see the other side of the case. So I don't want much from my students. I only want one thing from my students, and that's everything. You know, when I give reading assignments, unfortunately, this class has a book that's 2,000 pages long. When I give reading, and I've tried to be careful about cutting out sections of the book that you don't have to read. But when I do give the assignments, you should be reading, you know, the dissents, the notes, and everything that goes with. It's like learning a new language. You know, this is like a new language for a lot of you. All right, Massachusetts versus Environmental Protection Agency. This is an unfortunate case to put early on in our discussion about standing. It's not an easy case, but I think we can still derive some lessons out of it. So let's talk politics for a second, and we're not going to do it in other than an observational way. We know, we've already discussed, that the executive branch has a lot of agencies, a real lot of agencies. And these agencies are all very focused, and they tend to concentrate on, you know, sort of one area of inquiry. So for example, the Environmental Protection Agency was created in 1970. Can someone tell me who the president was who signed the bill into law? Richard Nixon was the president when the EPA was established in 1970. The Environmental Protection Agency, if you read the regulations and the rules, you would have no idea what they're talking about. You know, it's something that chemical and environmental engineers would understand, but that we would not necessarily understand ourselves. And they're talking about, you know, certain emissions in parts per million. And while I understand what carbon dioxide is and what methane is and what some of these pollutants are, I have how many parts per million means nothing to me. But it does to, you know, the people who work for the EPA, and it does to the producers of these materials that get released into the atmosphere. Or into the ground or whatever, okay? The Securities and Exchange Commission is the same. The securities laws are very, very complex laws. People who practice securities law are specialists. They do that and not much else. They tend to work in Wall Street, in Washington, D.C., and other financial markets. You know, it's sort of a specialty. Now, here is the fact, okay? Here's the political fact. Some people think that the government is too big, too unwieldy, and too out of control. This would be sort of the anti-federalist Thomas Jefferson viewpoint. This fight is still going on today, okay? Too many regulations hinders prosperity, hinders the abilities of businesses to earn a profit, generally wastes a lot of time for all Americans. Let's cut regulations and make the government more efficient. The people on the other side, the people who would have been Alexander Hamilton, the Federalists of the time, and again, there are still people like this now, think that the federal government is our friend. It is there to help us, and if it's not, it should be there to help us, and that the way that it helps us is by creating all these layers of bureaucracy and promulgating rules and regulations that, you know, Americans need to follow. There is no doubt that the world is far more highly regulated than when I was a child. And there is no doubt that there are politicians who generally are looking to cut down on the regulations. Now, again, this is an observation, and I believe it's an accurate observation. Republicans tend to be small government people. They tend to want to see regulations cut. Democrats tend to be big government people. They tend to view the benefit of these regulations as being worthwhile, okay? And so what happens when what happens, for example, in the antitrust division of the Department of Justice, when a Republican president is elected and starts appointing people to the Securities and Exchange Commission and starts directing, the Attorney General starts directing the antitrust division to prosecute cases or not prosecute cases. When a Republican administration comes in, prosecutions in civil lawsuits for antitrust violations dwindle. There are fewer of them. They still exist, but there are fewer of them. Then when a Democratic president comes in, they tend to increase. You get more prosecutions, okay? Let's go to the case at hand. What happens when a Republican president, who tends to be, you know, more disfavoring of rules and regulations, When the president gets elected, what happens with the Environmental Protection Agency? It becomes less active. It prosecutes less often. Okay. What happens when a Democratic president comes in? The prosecutions go up. And I'm talking about both criminal and civil prosecutions go up. These are our two opposing views of government that have been there since the founding of the Republic and are going to continue to be here until long after we're gone, right? The big government people versus the small government people. And there's no right or wrong answer. This is viewpoint. This is the way we view our politics. And most of us, our politics are fixed when we're fairly young, usually by, the politics of our parents, quite frankly. There are exceptions to that, obviously. So that's sort of the backdrop of Massachusetts versus the Environmental Protection Agency. The Clean Air Act requires the administrator of the EPA to set emission standards for any air pollutant from motor vehicles or motor vehicle engines, which contributes to air pollution and might endanger public health or safety. In 2003, who was the president in 2003? Reagan was president until 2000. Which Bush? W. George W. Bush. Bush 43. Bush 41 was from 88 to 92, and then came Clinton, and then came W. So a Republican president. Do you think the Republican president is making the EPA go out and raise standards, increase standards, regulate the industries? Nope, that's not what Republican presidents tend to do. That's what Democratic presidents tend to do, and elections have consequences. So the EPA makes two determinations. One is it lacked authority under the Clean Air Act to regulate carbon dioxide and other greenhouse gases. GHG is a greenhouse gas to abate climate change. And two, even if it had such authority, it would decline to set them for motor vehicles. The philosophy was that the effect that motor vehicles have on greenhouse gas emissions is relatively low. So Massachusetts and other states say, hey, the Environmental Protection Act of 1970 is enabling legislation that requires, it's passed by Congress. Congress makes the law, and the EPA is an executive agency. They're required to implement and enforce the law. And what's happening here is the claim in the lawsuit that the EPA is not implementing and enforcing the law. They are ignoring standards, regulations, and they are interpreting them in such a way as to frustrate the purpose of the original Environmental Protection Act. That's the argument. Those are the arguments that are being held here. Anyone know why I have a picture of this fellow here? Can someone tell me who this is? Let me give you a hint. Who wrote the decision? Stevens. That's John Paul Stevens, known for his known for his bow tie. Very quickly, is it Sam? Thank you, Sam. So Sam's question is, if Congress, if the EPA, if Congress, in passing the Environmental Protection Act, did not give the newly established Environmental Protection Agency the procedural mechanism to go out and to pass rules and regulations, can the EPA, the Environmental Protection Agency, go out and do that? And the answer is no. Because remember, the argument there would be a separation of powers argument, Sam. The argument there would be that the EPA is an executive agency. Executives don't have the right to make laws. Only Congress does. Now, we're going to talk about something later on called the non-delegation doctrine. And what we're going to see is that sometimes Congress passes a law that gives you the big picture, okay? What is the big picture of the Environmental Protection Act? Cut down on air pollution, cut down on water pollution, cut down on, toxins that are harming society, cut down on climate change that's caused by carbon emissions. That's the big picture. But Congress doesn't fill in all the details because it's a very technical job that the EPA has to do. So what it does is it has said, hey, EPA, you have the authority to fill in the details. This is the goal that we want to accomplish. But you guys are the experts. You're going to be hiring scientists. You fill in the details and then make them rules and regulations, okay? And that's been deemed okay within certain limitations. And we'll talk about those later on, okay? Does that generally answer the question, Sam? Okay, thank you. All right. So Stevens writes the opinion. By this point, Stevens was appointed by Gerald Ford, Ford's only appointment to the Supreme Court. Stevens was at first considered to be a sort of conservative justice. A lot of people believe that Stevens became more liberal as the court became more conservative. Ronald Reagan, George H.W. Bush, and George W. Bush tended to appoint, pretty conservative justices, conservative in the judicial sense, justices. And so some said that Stevens became more liberal, sort of as a foil to that. Stevens himself said, I'm a lifelong Republican and I will die a Republican. He was famous for saying, it's not me that has changed, it is the court that has changed. But that's an argument that, I think a lot of people would dispute. So by this point, Stevens is voting sort of against the conservative side of the court, the Scalias, the Alitos, the Rehnquists, those types, the Thomases, and seems to be sort of being paired up with the big government side of the Supreme Court. So he says here, the EPA does have a duty to promulgate and regulate greenhouse gas emissions. It does have a duty to try to protect the environment and prevent climate change. Massachusetts has concrete interests that it has to, and here we're talking about injury in fact, right? If you look at the top of the slide regarding injury, the court holds. Massachusetts itself, not just taxpayers in Massachusetts, not just property owners in Massachusetts, the state of Massachusetts itself owns a lot of land. And a lot of land that's going to be affected by climate change as the sea level rises. It's going to lose a lot of valuable land as a result of that. So Massachusetts is in fact injured. The part of this that's difficult, and I would ask you to sort of ignore this at this point. Stevens says that states like Massachusetts, sovereign states, seem to not have to show as high an injury as individuals who are not sovereign states have to show. And I haven't seen that repeated in a lot of cases, so I'm going to ask you to sort of ignore that. I don't think you'll see that on the bar exam. So here's Robert's dissent. Robert's dissent is, well, whoa, wait a second. Injury in fact, Massachusetts doesn't have any more injury than California. Doesn't have any more injury than a private property owner who owns waterfront property. Greenhouse gas emissions are causing climate change and are harming everyone. This is not a particularized grievance. This is a general grievance. This is not the type of injury that people should be able to sue over. And what Robert says in his dissent, since all pollution is shared throughout the country, we should be leaving these decisions to Congress, not having the courts decide that the plaintiffs can go forward here. Stevens comes back and he says, look, whether it's shared by people in general, there's still harm here. And the question is, you know, whether there is individual particularized harm as to Massachusetts, which there is, because they're suffering the loss of all this property. So again, this is a fight that you know is the typical disagreement between the two sides of the Supreme Court. On to causation. So in this one, the sort of let's be more forgiving with the injury in fact requirement side of the court wins. Okay. Stevens says there's you know, I guess maybe the EPA, if you want to say it made a mistake in an argument in regard to causation, its mistake was that it admitted that greenhouse gas emissions create climate change, and admitted that man-made greenhouse gas emissions created climate change. Stephen says, given that, there has to be a judicial remedy for that. The EPA doesn't have to solve the whole problem at once. It can make incremental steps to improve. It's got the power to do that, and it is neglecting its power. So there is causation back to the EPA, is what he is saying. Redressability, we're going to see a strong dissent here again. Stephen says, look, even if you don't solve the whole problem by making the EPA do its job, you're going to help out a little bit. And every little bit of help is an improvement. So there is redressability. If you order the EPA to, you know, follow the regulations and to work to protect the environment, then there is going to be some benefit from that, meaning there is redressability, okay? And again, you're looking at two people who are talking past each other, right? And I'm not blaming them for doing this. This is the big fight, okay? Conservative justices think too many people get access to the courts and the courts should not be setting policy. Liberal justices think that not enough people get access to the courts and the court should be taking a stronger role in enforcing the law, in interpreting and enforcing the law, okay? And telling the executive agency when it hasn't done its job by looking at the law. So Robert says, you know, number one, this is shared worldwide. Number two, even if we in the United States do our part, how about China and India? You know, they're pumping out a lot themselves and we're not going to cure the whole problem. Again, Stevens would come back and say, the problem there is that you can't cure the whole problem at once. We allow Congress to cure the problem on a step-by-step basis. Court should be able to do the same.
Can I just ask, I just have you now on Zoom. Is it me or is it the whole, did you put the slide off?
Nope,
No.
I see everybody on Zoom.
It's me.
I
All
think
right.
I think you must have hit a button, Karen. There's different views you can do. And I think you must have hit a button to just put yourself on.
All right. Well, I can hear you, so I'll just
Um,
stay safe and
Yeah,
if I
okay. You
go
don't,
around, I'll-
trust me, you're better off listening to me than to listen to me and have to see me at the same time. So I don't think there's much of a loss there, okay? So do you
sorry,
guys,
I can see you. I can't see the PowerPoint, but that's okay. This is taped, so I can go back to it. But
I think you must have minimized your screen. And what I might suggest is that you open up the PowerPoint on, if you can do that, open up the PowerPoint on Twen.
yeah, I will. Oh no, I
So
just
right now I'm on slide 23.
go ahead. I don't wanna.
But if you just hit the Zoom icon, it will pop up the slide again.
Now I missed. Now I don't even have him on whatever I touched. I can't even see him, but I can hear him. So go ahead.
Okay. So this is the kind of argument that you're going to be making in an essay. Do you guys see this? Right? You're going to be saying, you know, the government would argue this, the EPA would argue this, and Massachusetts would argue that when you get a fact pattern like it. You know, and you produce the counter arguments as well. So that's the value of this case. Unfortunately, it's a very difficult case this early in, okay? Once again, let's review the constitutional requirements. Are we ready all together? Injury in fact, causation, redressability, injury in fact, actual, concrete, particularized, and imminent harm. See how I've gotten a little more expansive now after the Massachusetts case? Causation, fairly traceable to the defendant's conduct. Redressability, a favorable court decision will abate the injury or provide compensation for it. Let's go to the City of Los Angeles versus Lyons. And we are here going to answer an early question that Karen at home had for us. Is there a difference in regard to standing when one of the remedies sought, when a remedy is a legal remedy, legal remedies are monetary damages, versus an equitable remedy? The equitable remedies will be injunctions, probably first and foremost. You guys remember from contracts, specific performance would be an equitable remedy. Declaratory judgment would be sort of a quasi equitable remedy. Those are the types of equitable remedies that we're talking about here. Interesting in the news, this is 1983, City of Los Angeles versus Lyons. This case involves the police putting a man in a chokehold. Lyons was detained. He claims he was stopped for no good reason at all. There seems to be a district court decision agreeing with him to some extent on this. He was then put into a chokehold. He claims to have been offering no resistance or no threat whatsoever. The officers just put him into that chokehold, knocked him unconscious, and caused damage to his larynx. He is suing for a constitutional violation. You will start to see cases, so-called 1982 cases, civil, constitutional tort type cases. These police cases tend to be under 1982 and 1983 is more commonly brought. 32 USC 1983. So Lyons is seeking two remedies. He is seeking monetary damages, and he is seeking an injunction to restrain the LAPD from using chokeholds in the future. He alleges that it is apparently a policy of the LAPD that they subdue detainees by chokeholds here. There is no dispute that Lyons has standing in regard to monetary damages. To have standing, you don't have to prove your case, right? You don't have to prove that you're going to win at this point. You just have to show that, you know, if my case has merit, there is injury in fact, there's causation, and there is redressability, okay? I have injury in regard to monetary damages because my larynx is damaged. And I'm sure I'm suffering pain and I've got pain and suffering damages, emotional distress damages that I should be compensated for. The city of Los Angeles is not claiming he lacks standing for monetary damages. The city of Los Angeles is claiming that he lacks standing in regard to the injunction. Now let's look at injury in fact, and let's go back and take a look. Has suffered or will imminently suffer actual, concrete, and particularized injury, okay? That's what's being required. The court says no standing for the injunction. The reason there's no standing for the injunction is Lyons can't show that if he drives out tomorrow, he's going to get stopped by a cop and then put into a chokehold. Lyons can't show that if he goes out a week from now, he's going to get stopped by the cops and put into a chokehold. This is what he would have to show to get the injunction. He would have to show that there was a real likelihood that if he went out in public, he would be detained by a police officer and put into a chokehold. That may happen to other people if it's a policy of the LAPD, but it's not going to happen as to him. So there's no particularized harm that he is alleging in regard to the injunction. Okay, again, he is in regard to the damages, but not the injunction. Does everyone see that? Okay. This is sort of a big case. It's in your note.
Can I ask you a
Lujan,
question
go
about
ahead quickly.
the injunction? They have 5 parts to it. So would it matter if it's the harm that you want for the standing? The other pieces for the injunction, would that didn't note the that has nothing to do with the standing piece, right? You know what I'm saying?
No, that's right. You don't look at whether there's a likelihood of success on the merits
Okay. All
when
the
you
other
do
things.
standing.
Gotcha.
Okay.
So it's the harm that you're looking at.
And so it's a lower factual threshold
Gotcha.
than say for a motion to dismiss a 12B6 or a motion for summary judgment, where judgment should be there are no
Right.
material disputes, in fact.
Right. So you could, if you had the harm, you'd have standing, but you may not get the injunction because you
Yep.
might not have the other issues. I got you, but we don't care about that for this. Got it.
Yep,
Thanks.
that's right. Okay.
Yeah.
All right. So Lujan versus the Defenders of Wildlife. There's this federal law, the Endangered Species Act. The Endangered Species Act is, you know, the aim of it is to protect wildlife that is deemed to be under the act endangered. Types of animals that face the threat of extinction, essentially. And the Department of the Interior is required to enforce the Endangered Species Act. And it enacts new regulations, and the new regulations narrow the scope of the enforcement area that the Department of Interior is going to regulate. It apparently used to apply throughout the entire world, you know, so places where the United States of America had engaged in some type of action in foreign countries, as well as in the United States itself. A number of American citizens brought a lawsuit challenging the regulations, saying that essentially they sort of abrogated what the Endangered Species Act was supposed to do. They wanted the Endangered Species Act to apply even on foreign soil. The Department of the Interior brings a motion to dismiss the case for lack of standing. The act itself does authorize citizen standing. So that would mean you have prudential standing, right? But what is Congress not allowed to waive? Constitutional standing, okay? Constitutional standing. So the question then becomes, is there injury in fact, causation, and redressability? And the court here says that there is no injury in fact. And we'll go through all three of these again. So I call this the rule that comes out of this is you need an airplane ticket in your hand rule, okay? For the type of injury in fact that we're talking about. Vague travel plans are not enough. You need to have purchased that airline ticket and know when you're going. So Scalia writes this decision. Now, some people loved Scalia and some people hated Scalia. Whichever side of the equation you're on, he was a legal genius. And his decisions are incredibly well written, incredibly well crafted. You may disagree with them. They're often very funny, and he's very sarcastic as well. Okay, and you can see him in this opinion taking little stabs, you know, at the animal lovers here, as if they're just a bunch of crazy tree huggers, you know, who are running around. It doesn't come right out and say it that way, but you can just sort of, you can sort of sense the tone of the written opinion that is in there. So he starts out by saying the right or desire to observe certain animal species is cognizable under the law for the purpose of standing. If someone deprives me of the right to go bird watching, that would be a cognizable injury. I'm not really a bird watcher, but you know, I'm just giving you an analogy, okay? However, it's more than just any injury. It's got to be those things that we talked about: concrete, particularized, and imminent injury, not some vague or speculative injury that may or may not arise in the future. And so you've got these two folks who at least try to meet the level of particularized injury. They signed declarations, which in some federal courts they call them declarations, in other federal courts they call them affidavits. They signed declarations. Kelly said 6 years earlier, 6 years before this case was decided, he had traveled to, she had traveled to Egypt and had observed in the natural habitat the endangered Nile crocodile. She says she wants to go again. I'm sorry, but this just reminds me of when my kids were little. Their favorite book. Did anyone ever read this book when you were kids, or read to your kids? Lyle crocodile. So when I see Nile crocodile, I'm just thinking of Lyle crocodile. But whatever. And then there's a guy. Again, she says she's going back. She doesn't say when, but she says she's going back. And then Skillbred went to Sri Lanka in 1981, about 11 years prior to the decision of this case, where he had seen two animals that were endangered, the Asian elephant and a leopard, and she intends to return to see them again. You know, no airline tickets in hand, no no specific claims as to when that would be. Scalia says this isn't good enough. This is not that direct, concrete, particularized harm that we need. This is vague. Vague plans to return are not concrete plans to return, so there is no concrete, particularized harm. He then goes on to redressability. Skips over causation, goes on to redressability. He says, well, when it comes to redressability, there's, there's no, real claim that the Department of the Interior is really doing anything here. This is sort of a generalized claim against the government. There are other agencies that are involved that aren't even parties in the case. If we issued an injunction is not binding on a non-party, okay? And of course, there's one other issue that doesn't show on the slide, but should be mentioned, is to the extent that these activities are occurring in foreign countries, the foreign countries might be involved in those activities, and they're not going to necessarily honor an injunction that's been issued in the United States for people who go there. So he says the big problem is lack of particularized injury, imminent injury, and there's also no addressability. Even if we gave you the relief that you're seeking, the injunction saying that you have to enforce these rules in foreign places wouldn't necessarily solve the problem. United States versus Hayes. We're going to be doing apportionment cases all semester long. You guys know what year this is, 2020? It's the decennial year. Every 10 years, the federal government is required to do the census. And for our purposes, the most important reason why it does the census is to establish how many representatives each state gets in the House of Representatives. Article 1 of the Constitution deals with this. Article 1, Section 3. Representatives to the House of Representatives shall be apportioned among the several states according to their respective numbers. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States and within every subsequent term of 10 years. So we had one in 2010, 2020 is another one. Next one is going to be 2030, okay? And as you know, the census has been in the news recently in terms of political disputes. It's been in the news. So every state, no matter how small, gets one representative, okay? The larger states get more representatives. So Alaska, Delaware, North Dakota, South Dakota, Vermont, and Wyoming are the smallest states in the United States population-wise. We know that Alaska is the biggest state area-wise, but it is not the biggest state population-wise. Wyoming, in fact, is the smallest state population-wise. They get only one representative. So they have one representative and 2 senators, right? Every state gets 2 senators, regardless of size. So the House of Representatives is a proportional part of the legislature. It is directly related to the number of people there are in the state, more or less directly related. California is by far the most populous state in the country and therefore has the most representatives in Congress. They have 53 representatives in Congress. Alaska, Delaware, North Dakota, South Dakota, Vermont, Wyoming only have 1 representative in Congress. For those small states that only have 1 representative, how many electoral votes are there for running the president, for electing the president? Who says 1? Who says 2? Who says 3? The answer is 3. Electoral votes are determined by adding up the number of representatives and senators that the particular state has. Okay? So California is the biggest prize. California is the biggest prize in the presidential election. Okay? There's also, I think it's 2 that go to the District of Columbia, by the way, even though it's not a state. In the presidential election, they get 2 electoral votes. New Hampshire has 2 representatives and 2 senators. Massachusetts used to have 10 representatives, but that dropped to 9 because of the 2010 census.
Do
You know,
we
I
have
say
to
here
know
that
this? Do we
What's
know
that?
this? Did we study this for the exam? Or is it just common knowledge you like?
no,
to-
no, 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 no.
We
You don't have to know how many representatives Massachusetts
Okay.
has.
All right.
Okay.
All right.
You need to know how our government works.
Okay, yeah, that's what
You,
I
you
just,
need to know. You need to know. This is a constitutional question. You need to know why we do the census every 10 years, because it leads to a determination of how many representatives are going to be there. Okay. So the biggest prizes are number 1, California, number 2, Texas, and I believe Florida's 3rd. I believe Florida is the 3rd most populous state. So in Massachusetts, we would have 11 electoral votes for president, 9 representatives and the 2 senators. And by the way, Massachusetts' population didn't drop, it just dropped in relationship to the rising population of other states. You guys understand that the population of the Sun Belt states, the South and the West, are rising much more quickly than the populations of the Northeast. Okay. Okay. Back to our case, and I think we'll have to end it. I might be able to quickly get in Clapper. Yeah, I'll be able to quickly get in these 2 quick cases. So let's bottom line this case. These folks are bringing an apportionment lawsuit. Okay. Now take a look here. I think I drew this on the slide. That is California that you see in the cartoon picture there. And those are the representative districts in California, okay? And when you see this, there are different ways that states do apportionment. And they often do them, they used to do them for racial purposes, to suppress the black vote, okay? Especially in the South. It is more common for them to do it for political purposes. So for example, in Massachusetts, who do you think the way they draw the districts, the way that the Massachusetts legislature has drawn the districts, who do you think that favors, the Democrats or the Republicans? That would be the Democrats, because who controls the government in Massachusetts? And then in Texas, who do you think those would favor? The Republicans. You get the idea, right? Okay. And this is a constant battle. And there's a recent case we'll be talking about, a couple of recent cases we'll be talking about when we get to the political question doctrine later on. So these folks are saying that the districts have been drawn in such a way as to discriminate on the basis of race. And they bring a lawsuit because of that. And why is there no injury in the case? Real simple, bottom line. No standing. Why is there no standing? They don't live in any of the districts that are claimed to have been apportioned on the basis of race. They don't claim, in other words, there's no injury to you. You have to live in that district if you're going to sue, saying that the district has been drawn so as to suppress the African-American vote or the like, okay? Clapper versus Amnesty International. The FISA Act, there's a FISA court that exists. The FISA Act deals with intelligence and largely has been, it's a secret court where the government will seek to, say, wiretap or to take, these days, a lot of data over the internet from foreigners, from foreign people, who, and these days the focus tends to be on terrorism, who are engaged in terrorist activities. The problem is that they're often tapping into phone calls and email exchanges and texts of these foreigners who are speaking with Americans, which means not only are the foreign conversations getting picked up with these secret warrants, but the American counterparts' conversations are. And the claim is that that's not supposed to be the case under the Foreign Intelligence Surveillance Act. And a bunch of lawyers and human rights advocates who believe that they would be wiretapped because they correspond with some of the targets of these taps, claim that their rights have been impinged, and the majority throws the case out for lack of standing. Alito writes the opinion, and he says that you've shown nothing. This is vague. You don't know. And again, you see the dissent going on here. The disagreement. It's all the same. The majority says, you know, you haven't shown enough, and the dissent is always saying, yeah, we've shown enough. There's a likelihood that this is going to happen. That's good enough. You guys are making the standard way too high. Okay, it depends which side you're on. You want the court to be more active or less active when it comes to these types of cases. All right, we will end it there. We got a few more cases. We'll run through those fairly quickly on causation and redressability on Thursday. And I will get you out probably later tonight. I will get you out the answers to the quiz that you guys took over the weekend, okay? Take care, guys.
How do people do on the quiz in general?
All over the place. Don't worry about the quizzes, okay? They're gonna be hard, and you're all gonna suffer together, okay?
Okay.
All right.
Thought it was hard.
Professor,
Yeah, quick.
just this con law is much easier than your properties class, so I'm so glad that I already had properties.
There-
Oh,
Oh,
really?
good. There you go. There's one observation.
Was that
You
Lisa?
made,
Yes, hi Linda.
Hi, Jay.
you made the rest of the class feel really good, haven't you? You haven't taken
Hi
property
Dave.
yet. Take care, guys.
Bye.
Ah. Today the primary? Okay, why can't I get this button to turn it off?
I can't leave it. I'm trying to figure out how to. I'm just gonna exit out. Okay, bye. Okay.
Jeez. Just leave me alone for a second, Teddy. Hold on. I gotta turn this off.